John Waltz Suwan. Non-beneficiality is Feliz Calanoy. And non-practicability is Lynn Maris Bal. And now let's meet our distinguished judges. First, we have VPM Alexis Vian Regala. Next, we have former Mindanao Governor Hermie Viray. And presiding as our chief adjudicator is Asimbeda College law student Dwight Sambat. In today's proposition, let it be resolved that libel should be decriminalized. First up, for the affirmative side, Ronan Alvin Sescon, you've got 4 minutes to tell us why libel should be decriminalized.
Thank you. Good afternoon, Your Honors. Imagine this, 1909, Pampanga. I, along with like-minded individuals, are waiting to sign a petition for the removal of a justice of the peace due to no negligence of his duties. We were charged for uttering false and scandalous machinations that were allegedly defamatory and libelous towards the said justice. Court dates were set, and knowing full well that we were up against one who can wield the words of the law like a fine blade at war, we sleep each night, or at least make fervent attempts at doing so, however unsuccessfully, in the sheer fear that we may very well be imprisoned should unbridled power and influence trump over justice and take the reins. Fast forward to early 2000s, Manila. I am a concerned citizen denouncing a barangay official for the misconduct of his office. I wrote of the misconduct in a newspaper, and not long after that was charged with libel. The case in the court dragged on, and suffice it to say, while I take heart in the fact that I'm doing something right in the defense of the good office stained by one corrupted soul, I still fear that for how much power an individual can hold against me, even so far as to conjure the often vindictive hands of justice, of the courts of justice, to soil my very right of free expression. Skip to 2018. I am a renowned journalist. I am supremely vocal about the mishandling by the current administration of the military resources on its impunitive war against drug and corruption and on its lackluster efforts in defending Philippine territories. I was charged with cyber libel over some articles I wrote over decades ago by a law enacted only 4 months after the articles were published, as if by some insidious plot to silence me for standing my ground, expressing my thoughts, as is my right, and fulfilling my cardinal duty of defending freedom of expression, press, and of speech. I honestly wish I could tell all of you that the tales I have just relayed were excerpts from George Orwell's 1984. Sadly, they are real tales experienced by real individuals across more than a century's length of Philippine history. Many of you may have already known that what I have stated are among others, the cases of U.S. versus Bustos, Vasquez versus CA, and that of Rappler's Maria Ressa, who needs no introduction in this noble congregation. Serving as a refresher, of course, first, I honestly, more importantly, the reason for my poor man's retelling of the aforementioned cases is simple. I want to make a point for so long that our libel laws, while they have initially been geared towards protection of private citizens from unwanted danger of on their reputations, have now essentially evolved as a tool to deter free speech, and it isn't as if it wasn't obvious enough from the litany of cases. Under Article 353 of the Revised Penal Code, libel is a public and malicious imputation of a crime or a vice or defect, real or imaginary, or any act, omission, condition, status, circumstances tending to cause the dishonor and discredit to contempt of natural or judicial persons, or to blacken the memory of someone who died. Banked on this particular provision also is the Cybercrime Law of 2012. Now, the whole spiel of the affirmative speech is simple. We want to remove the criminal aspect of our current libel laws, both from the RPC and that of the Cybercrime Law of 2012, on one very important ground. It is a necessity because there is a constant and perpetual danger that the aforementioned laws can, still is, and will still be used to deter free speech and freedom of the press so long as they remain operative. Owing deference to, and certainly notwithstanding the cases I just reiterated with passion, it cannot be stressed enough that in allowing these libel cases to prosper, a chilling effect is essentially created, designed to inhibit or discourage journalists, media personalities, basically anyone to exercise their right to speak or to call out discrepancies, especially against those in power. The effect can be as minute as veiled threats of suit, or to more significant acts like dragging litigation, staggering attorney's fees, etc. All of these for the insidious purpose of staying one's hand in the practice of one's right. Remember, alongside free speech is the freedom of the press, which is a constitutionally guaranteed right as is enshrined in Section 4, Article 3 of the Constitution. To wit, no law shall be passed abridging the freedom of speech, of expression of the press, of the right of the people peaceably to assemble and petition the government for redress of grievances. Thus, if such weighty significance is accorded to these primordial rights, why are we still allowing libel laws to be used by those in power to stifle free speech? Aptly worded in House Bill 3455, the subject laws that have been increasingly used by public officials as a tool to cow and muzzle the independent press. Stepping into the shoes of the opposition now, so to speak, even if they argue that there is a shaded necessity coming for individuals to be able to file libel cases as they are the means to achieve redress from defamatory wrongs, serving also as a deterrent against them.
Speaker, time's up. Thank you so much. Now, John Waltz, you have 2 minutes to cross Ronan. You may now begin.
Good afternoon, Council.
Afternoon.
Counsel, are you aware? Are you allowed to besmirch the good name and reputation of a person?
Under our current laws, no.
Recording in progress.
So that libel, libel is called character assassination.
What?
You agree with me, counsel, that libel is called character assassination?
In a form, yes.
Then would you agree with me that its perpetration disturbs the public order?
Not necessarily, no.
Is it or is it not libel is inherently evil?
No.
No. Therefore, decriminalizing libel is not the answer, right?
Decriminalizing libel is the answer.
No. Are you aware, counsel, that libel laws are generally regarded as valid exceptions to the constitutional guaranteed of freedom speech?
Yes,
Therefore, decriminalizing libel is not the answer, right?
but that depends on the court ruling.
Is it or is it not, counsel?
Not
that
necessarily, counsel.
libel
No.
is to render the state powerless in addressing and penalizing this social harmful conduct?
Again, counsel?
Is it or is it not, counsel, that decriminalizing libel is to render the state powerless in addressing and penalizing this socially harmful conduct?
No, because we have deterrence against that.
No. Oh. Therefore, decriminalizing libel is not the answer, right?
No, we have deterrence. Civil Code,
Your
Article
question.
26.
Okay, time's up. John Waltz 1. You have 4 minutes to advance your argument on why libel should not be decriminalized. Your time starts now.
These days, the prevalence of mudslinging and cyberbashing cannot be denied. Even a simple exchange of opinions can turn into a heated argument. Thanks to the immense popularity of social networking sites, the Philippines is considered the social networking capital of the world. So, if you are looking for some words of wisdom, the internet is probably the suitable place you would consider to go on. Your honors, ladies and gentlemen, good afternoon. We the negative adheres to the status quo in criminalizing libel. I, Mr. Suan, will prove to you the non-necessity. Ms. Calano will discuss the non-beneficiality. And lastly, Ms. Bal for its non-practicability. But before I come to my own arguments, let me rebut some points made by the first speaker. He pointed out about the freedom of speech. Libelous statements does not have immunity from the Constitution that is clearly ruled in a jurisprudence in Gainging case. So to my first point is libel is malum in se, that is offense that is inherently wrong. Libel per se is evil in itself. Libel is called character assassination, and like other assassination, its perpetration disturbs the public order. It is thus properly the concern of criminal law, which is to preserve public order and decency to protect the citizen from its offensive or injurious. Libel laws are generally regarded as valid exceptions to the constitutional guarantee of freedom of speech. Libel often takes a form of sharp personal attacks and goes by such names as calumny, epithet, invective, ridicule, or similar words of art in the lexicon of defamation. Is not in any proper sense the communication of ideas protecting by the Constitution, referred to the U.S. Supreme Court as the lewd, the obscene, the profane, and insulting or fighting words, those which are their very nature inflicting injury, that are so the slight social value as a step truth that any benefit that might be derived from any is clearly outweighed by the social interest in order and morality. Second is decriminalizing libel is not the answer. No one has the criminalizing libel is precisely to allow irresponsible persons to, so to speak, get away with murder without any accountability whatsoever. It is to allow trolls and paid hacks to reign supreme and lord over the internet. Now, the law on libel was never meant to stifle the legitimate exercise of the right of free expression, but to deterrent against its abuse. It is the law itself, but its misuse that sends a chilling effect on those who dare to speak the truth. But should there be a chilling effect? Is it precisely that in the needed against those who abuse their right of free expression? All penal laws have inherent chilling effects, and to decriminalize libel, it is to render the state powerless in addressing and penalizing this socially harmful conduct. Why decriminalize libel? We can propose other mechanisms like alternatives, which the affirmative failed to lead in this debate. Libel may be private wrong or public wrong, or perhaps both, depending on the identity of the party bringing suit or type of remedy sought. As a private wrong, it involves an individual or small group claiming to have defamed or suing for civil libel, possibly collecting monetary damages or for harm suffered. As to public wrong, on the other hand, libel involves the state criminally prosecuting a person who it believes that defamed another, including another individual, a public official, a government entity, a large group, even a deceased person. If
Time's
government
up, John. Time's up. Thank you very much. Now, Ronan, you have 2 minutes to cross John. The time starts now.
Thank you. Council, are you aware that our libel laws under Article 353 of the Revised Penal Code and that of the Cybercrime Law of 2012 are being constantly used to inhibit individuals and press to speak out against those in power?
Yes, Council.
Good. Do you agree that there is an undeniable potential for said laws to be skewed in favor of the powerful and the influential?
Maybe.
Okay, that is a yes. And do you agree, a segue a bit, do you agree that the freedom of the press is a constitutionally guaranteed right under Section 4, Article 7 of the Constitution?
Yes, freedom of speech.
Okay, good. Do you also agree that in the hierarchy of civil liberties, the rights of free expression and of assembly occupy a preferred position as they are essential to the preservation and vitality of our civil and political institutions, correct?
Yes.
Then you should agree that any law that poses to abridge the rights of free expression and of the free press should be struck down, correct?
Come again?
Okay, I'll take that as a yes. Since you agreed to that, then are you aware of Article 26 of the Civil Code, Council? No, I'll take that as a no. Are you aware that it serves as a deterrent against defamatory remarks outside of those provided for in the RPC and the cybercrime law?
Come again, Mr. Speaker.
Are you aware that these laws exist, Article 26 of the Civil Code, serving as a deterrent outside of what's provided for in the RPC?
Yes.
Okay, good. Then there should be no reason for us to take away the criminal aspect of libel because we already have existing deterrents to punish defamatory wrongs, correct?
Correct.
Okay, good. That is all.
Thank you very much, John. Now, before I continue, may I request the guest to please turn off your microphone. To all the speakers, please turn off your microphone. Now, let's hear Jefferson. Jeff, you've got 4 minutes to tell us why it is beneficial to decriminalize libel. Your time starts now.
Thank you, Your Honor. The Supreme Court is clear in the case of Cadiz versus Brent Hospital that in the application of laws and governmental regulations, their provisions should not be interpreted in a manner that will violate the fundamental law of the land. However, given the current status quo where many individuals candidly criticizing the government and media personalities rightfully bringing news to the public are facing criminal charges on libel, tells us that libel laws are being used to silence their criticisms towards government officials, therefore compromising their freedom of speech or of the press. Your Honors, ladies and gentlemen, good afternoon. We from the government firmly believe that criminalizing libel is beneficial based on the following grounds. First, it provides more liberty in exercising the fundamental right of freedom of speech or of the press. Second, it causes the state to adhere to the doctrine of obligatio erga omnes. But before I proceed with my contentions, please allow me to rebut some of the worthy points raised by the previous speaker. The opposition is saying that by decriminalizing libel would result to lack or no deterrence at all, but they fail to realize that the Prime Minister has already identified Article 26 of the Civil Code to actually deter libel. Also, they mentioned that libel is a malum inse. While conceding to that fact, the contention of the government is that it is being used by the government or individuals to silence their freedom of speech. What we are protecting is the freedom of speech and of the press to which the government or individuals are using libel to silence them. They conceded that all criminal laws have their chilling effect, which what we are trying to prevent. That people who are just exercising their duties, such as journalists, will have the freedom to exercise their right without being charged with a criminal case. Now, for the substantive part of my speech. First, decriminalizing libel provides more liberty on individuals exercising their fundamental rights on freedom of speech and of the press. Section 4, Article 3 of the 1987 Constitution provides that no law shall be passed abridging the freedom of speech, of expression, and of the press. The opposition is trying to persuade us that criminalizing libel is proper to deter slanderous and defaming acts. However, the interpretation by certain individuals or groups, or even the government on using these laws, has evolved in such a way that this is being used to silence freedom of expression, more so freedom of the press. As established by the Prime Minister earlier, criminal charges on libel creates a chilling effect, and in fact, prolonged chilling effect on individuals and journalists. According to the 2020 SWS survey, 51% of the Filipinos feel that it is dangerous to print or broadcast anything critical to the administration, even if it is truthful. By decriminalizing libel, many individuals will be encouraged to speak without the fear of being charged criminally, and the citizens will be able to receive news objectively. For my second point, decriminalizing libel causes the state to adhere to the doctrine of obligatio erga omnes. Obligatio erga omnes in the case of Binuya versus executive is the state's obligations owed towards the community of states as a whole. Your Honors, in 2012, United Nations Human Rights Committee declared that criminal sanction for libel in the Philippines is excessive and in violation of Article 19 of the ICCPR, in which the Philippines is a signatory. As a signatory to ICCPR, we have the obligation before the world to align our laws, particularly on libel, with that of the provision of the ICCPR. This is just proper since this is consistent with the words of the Supreme Court. In the case of Bayan Muna versus Remulla, it says Philippines has adopted the generally accepted principles of international law as part of the law of the land. A portion of sovereignty may be waived without violating the Constitution. In this case, it is but proper that we align our libel laws with ICCPR by decriminalizing it, and thus be given the proper freedom to exercise our right to free speech in the press without the fear of being charged criminally. Thank you.
Thank you very much, Jeff. You had 12 seconds left. Now, Felice, you have 2 minutes to cross Jefferson.
Good afternoon, Council.
Good afternoon.
Council, am I right to say that the role of the press is to inform, criticize, and stimulate debate in their exercise of freedom of speech and expression?
Not necessarily debate. They are there to provide information objectively.
Thank you for that explanation, but I prefer a yes or no answer. Are you updated on the news and current affairs?
Yes, definitely.
Have you seen any of these shows, TV Patrol, 24 Horas, or any news show on YouTube or other platforms?
Yes.
Are you able to get your news on your cell phone or applications?
Yes.
Council, all those are activities freely exercised by the press in the current status quo. Therefore, there is no curtailment of freedom of speech and expression. They are
but
not.
But there is, given the cases
yes,
earlier by the Prime Minister. As you have known about Maresa.
Okay, thank you very much. So now, Felice, you may now proceed, and you've got 4 minutes to tell us why it is not in our best interest to decriminalize libel. Your time starts now.
Libel sets the balance between the fundamental rights of free speech and right to protect his own person and honor against lies and slander. We on the opposition firmly believe that libel should not be decriminalized. Instead, we propose alternatives laid down by our first speaker, Mr. Swan. But before I proceed to my points, let me offer counter-arguments against the points made by the affirmative. First, regarding the freedom of the press, I beg to disagree on this matter because progressive countries such as Iceland, Sweden, and Switzerland consider libel as a criminal offense. Therefore, there is no need to decriminalize libel in our country. Second, as I stated earlier in my interpellation, the press are able to practice their duty, which is to inform the public freely without fear of criminalization and prosecution. Therefore, there is no need to decriminalize. And on the issue of the Article 26, there is actually a proposed bill which adds third exemption to Article 354 and I quote, any discussion of any matter of public concern or criticism of official conduct or the conduct of public figures, unless such matter is shown by the prosecution to be false or to have been made by the defendant knowing its falsity or with reckless disregard of whether it's true or not. This bill aims to protect individuals who may be accused of libel in criticism of political figures in the exercise of their official functions. With that being said, please allow me to illustrate why it is not beneficial to decriminalize libel. First, the freedom of the press, if unchecked, is prone to abuse. Responsible and professional media is the backbone of democracy. They play a vital role in our society. They inform, criticize, and stimulate debate. If unchecked, however, the right to freedom of the press can be abused. As evidenced by the increasing number of court filings of libel cases, this same freedom is used to impugn the dignity and honor of public officers who we forget live private lives. They promote mistrust and dissension. Therefore, decriminalizing libel is in contrast to the function of the state, that is, to promote order in the society. If we can hold our officials accountable, the source of our information and news should be as well. Freedom of speech and expression should not be an excuse. Second, there's no presence of chilling effect against freedom of speech and expression. As evidenced by the large number of media outlets in the Philippines, there is no chilling effect. There is no prohibition of freedom of speech and expression. In fact, studies show that 85% still go online to get their news from news outlets such as ABS-CBN, GMA, and Philippine Daily Inquirer, and yes, Rappler. And since the lockdown, more and more Filipinos tune into media outlets for news and updates. Furthermore, we have seen growth in the media these past few years. In fact, major media outlets has embraced technology. Through YouTube's platform, they have ABS and GMA's news program, such as NXT and Stand for Truth, a daily newscast focused on data-driven reports. News outlets criminalize libel if the status quo is working. This just proves that there is no curtailment of freedom of press, speech, and expression. Therefore, libel should not be decriminalized. Ladies and gentlemen, as I have laid down, your honors, decriminalizing libel is not beneficial since first, freedom of the press is, if unchecked, is prone to abuse. Furthermore, there is no chilling effect against freedom of speech and expression. Freedom of speech is not a license of abuse. It is a responsibility. With that, I rest my case.
Thank you very much, Felice. You have 20 seconds left in your... Now, Jeff, you have 2 minutes to cross Felice. Your time starts now.
Thank you. Good afternoon, Council.
Good afternoon.
Earlier, you asked if I am updated with the news. Are you?
I am, yes.
Yes, thank you. And you said earlier in your interpellation that there are no current cases or status quo on where a journalist is being filed with libel, right?
I beg to disagree. I did not say
you
that.
said it during your interpellation.
I did not
but
say that.
Are you familiar with the case of Maria Ressa?
I am actually.
Yes, and isn't that libel was filed against her because of her way?
Just one of the many, actually.
Exactly. That's why.
But there are still reporters who
isn't it that she was just trying to exercise her function as a journalist?
Yes.
Yes, exactly. And are you proposed, and isn't it your position a while ago that there's no chilling effect when libel cases are charged against an individual?
Yes, and it is
yes.
still
Okay. Are you proposing, therefore, that chilling effects should be worded in our statutes?
Come again?
That it should be felt. Are you proposing, therefore, that chilling effect should be worded in our statutes so that it would be present?
No,
I will consider that as your answer. Okay. Isn't that chilling effect a subjective one and is felt by a person and did not be found in any statute?
As for your point, it is subjective.
Okay. I'll consider that as a neutral one. Let's go to my next point. Would you agree with me that freedom of speech and freedom of the press are constitutionally guaranteed rights?
Yes.
And that they should not be compromised by any statute?
With freedom comes great responsibility.
Right. Okay. Would you agree with me that the present libel laws are being used to charge journalists with the allegation? Right?
Come again?
Would you agree with me that at present libel laws are being used to charge journalists, like what happened to Maria Ressa? You
libel laws are there
earlier,
to protect.
right?
all the
You
citizens.
consider to that fact, right? And next, isn't that such
Thank you
criminal
very much,
charges
speakers.
against?
Thank you very much, Speaker Jeff and
you.
Feli. Your time is up. Now let's hear from our third affirmative speaker, Walbert. You have 4 minutes to tell us why it is practicable to decriminalize libel. Your time starts now.
Good afternoon, Your Honors, and to the members of the negative bench. It is our burden in this debate to overcome why we should adopt a transformative approach when it comes to libel that is radical and more liberal. We have totally overcome this burden as laid down by the first two speakers of our bench after how many years have passed, yet our libel laws are totally inconsistent with the 1987 Constitution and its continuous violation to our international obligations. However, as said by the negative bench, that decriminalizing libel renders the state powerless, totally erroneous because there are mechanisms in place in order to deter the proliferation of libelous statements such as Article 26 of the new Civil Code. The second speaker is trying to bend the narrative of the current status quo, cherry-picking some favorable factors but without mentioning any negative factors such as harassment to the journalists, and failed to provide any worthy rebuttals why those negative factors are part of the solution in upholding democracy in our country. Because as what is happening in this debate, the negative bench is advocating that publish at your own peril, but we want to emphasize in this debate that critics are not criminals. There are two scenarios in this debate. First, we're going to stick with the current status quo proposed by the negative bench. And second, we're going to adopt the proposition. As in the first scenario, assuming without considering if we're going to stick with the current status quo, press freedom has long been under attack in our country as repeatedly condemned by various human rights organizations. I can cite a lot of instances wherein a fair and true reporting made by journalists were omitted with the filing of criminal case right away, only to be dismissed by the court, or the petitioner will execute an affidavit of desistance. The most sickening part, we all know that those criminal cases were filed for the purpose of harassing our journalists or private citizens. The current status quo is journalists and private citizens are not fully enjoying their fundamental rights to freedom of press, speech, and expression as guaranteed by the Constitution and established by the first two speakers of our bench. The second scenario in this debate is when libel is decriminalized. While our bench concedes that the proposition is prone to abuse by some unethical journalists and ordinary citizens, but we have mechanisms in place to deter such abuse, which is to file a civil case.
I think the speaker was disconnected, so I just paused her time.
Nasa kabila siya, nandito siya.
Huh?
Nandito sa kabila.
Can you please wait lang nga, na-move sa kabilang.
I'm so sorry. Someone transferred me to another room. If I may repeat my speech.
Yes, you may, and your time now is.
We would like to apologize, Walbert. We will give you another 4 minutes for your speech. Thank you.
Thank you so much. Thank you so much. Well, allow me to recover for a moment.
Whenever you are ready.
Thank you. Thank you. I truly appreciate it. So let me begin my speech. Okay, I'm ready in 5, 4, 3. Good afternoon, Your Honors, and to the members of the negative bench. It is our burden in this debate to overcome why we should adopt a transformative approach when it comes to libel that is radical and more liberal. We have totally overcome this burden as laid down by the first two speakers of our bench after how many years have passed, yet our libel laws are totally inconsistent with the 1987 Constitution and its continuous violation to our international obligations. However, as said by the negative bench, that decriminalizing libel renders the state powerless, totally erroneous because there are mechanisms in place in order to deter the proliferation of libel statements such as Article 26 of the new Civil Code. The second speaker is trying to bend the narrative of the current status quo, cherry-picking some favorable factors but without mentioning any negative factors such as harassment to the journalists, and failed to provide any worthy rebuttals why those negative factors are part of the solution in upholding democracy in our country. Because as what is happening in this debate, the negative bench is advocating that publish at your own peril, but we want to emphasize that critics are not criminals. There are two scenarios in this debate. First, we're going to stick with the current status quo proposed by the negative bench, and second, we're going to adopt the proposition. As in the first scenario, assuming without considering if we're going to stick with the current status quo, press freedom has long been under attack in our country as repeatedly condemned by various human rights international organizations. I can cite a lot of instances where an fair and true reporting made by journalists were omitted with the filing of criminal case right away, only to be dismissed by the court, or the petitioner will execute an affidavit of desistance. The most sickening part, We all know that those criminal cases were filed for the purpose of harassing our journalists or private citizens. The current status quo is journalists and private citizens are not fully enjoying their fundamental rights to freedom of press, speech, and expression as guaranteed by the Constitution established with the first two speakers of our bench. The second scenario in this debate is when libel is decriminalized. While our bench concedes that the proposition is prone to abuse by some unethical journalists and ordinary citizens, but we have mechanisms in place to deter such abuse, which is to file a civil case. Worthy to note that there are only few journalists in our country found guilty for engaging into unethical conduct. This should not affect in any manner the progressive step that our country is going to take if we're going to adopt the proposition. Also, if ever such malicious imputation caused damage to someone's reputation, as said by the Supreme Court in the 1918 case of U.S. versus Bustos, the wound can be assuaged with the balm of a clear conscience. Bottom line, sticking to the current status quo will bring more harm than good compared to adopting the proposition. My main argument as to why adopting the proposition is practicable because it balances the interest of right of freedom, the freedom of expression and the right to reputation, which is our burden in this debate. And it is the burden of the negative bench to lay down that the status quo balances such interests also. And thus, the proposition should be rejected, to which they frustratedly failed to establish so far, even if it was used as an argument with the second speaker of the negative bench earlier. As said, the move to decriminalize libel is growing. A data gathered in 2016 provides way more the majority of the first world countries have no criminal defamation laws, such as United Kingdom, Ireland, and among others. 14 countries have initiated decriminalization of libel, including France, Croatia, which impose fines only. In the United States, 33 states have no libel laws on the federal level. There are no criminal defamation in the United States. Bottom line, these are first world countries, and they have big news media outlet with a multi-wide latitude of audience and coverage, but they choose to decriminalize libel because they're protecting the interests of the general population than the interests of powerful politicians and members of the society, to which the negative bench is advocating in this debate, Your Honors. Thus, it is our submission that we end punishing libel with a prison sentence, as it is a disproportionate measure and obsolete overreaction in the 21st century. Your Honors, it should be our collaborative effort to help make way for a more civilized and appropriate response through civil code provisions and not through penal code provisions. If we are to create an environment that allows the media to exercise the corrective function and encourage critical thinking, we should not allow a 1932 draconian libel law to continue making a grave chilling effect in today's more civilized and modernized society. With that, the proposition must be upheld.
Thank you very much, Walbert. You have 10 minutes left in your time. 10 seconds left in your time. Now, let's proceed to Lynn. You have 2 minutes to cross, Walbert.
Good
Time
afternoon,
starts
Council. Good afternoon, Council.
Miss Council.
Yes. I would like to stress that my questions be answered by yes or no only. So, it is already proven jurisprudence that libel is constitutional. Am I right?
Yes.
Yes, okay. Then, is the personal freedom of speech and expression above our collective right of the social order?
Are you aware, Council, that it's a fundamental right?
No, are you aware that we also have, as a collective community, we have the collective right
Council,
to social
jurisprudence
order and
established that right to speech and expression are fundamental rights. Are you aware of that?
That are personal. That are personal.
No,
Yeah.
totally wrong. You see, read some jurisprudence,
Let
Council.
me, you should as well. Well, would you agree with that the state is bound to protect itself?
Of course, I do agree with that.
Yes, right? Then you should have known that in civil cases, only the private respondent is the aggrieved.
But what
Right?
about the chilling effect, Council? How do you address such?
Isn't it not the duty of
Article 26 of the new Civil Code, Council.
civil liability? Criminal liability is different, Council.
Why
you
is
are
there person
focused-
criminal
let-
liability
let
in
me
this
say-
case?
Because criminalizing libel is a criminal liability. Maybe you have forgot that the proposition is decriminalizing it. So we are on the position to criminalize it, and the status quo is criminalizing it. Let me remind you that. Now you are focusing in political libel only. Then how about private libel? Do you expect the government to just leave them be?
Council, categorical questions. But if you want me to answer that one, Council,
But
well, I would
anyways-
definitely I'm
yeah,
very much happy to discuss with you that there is a thin line now, Council. That
Anyways, Council, the current status quo is working. Would you believe me or not?
no, you are just cherry picking small
Because-
factors here in this
no,
Council that is working.
Because the statistics shows that
What is your statistics, Council? Have you checked 2020 SWS survey? Have you checked the 2020 SWS survey?
It is my time to speak, Council. It is my time to speak. So I would appreciate
Time's
if you
up.
would be a
Time's
little-
up.
That would be all.
Time's up, speakers. Thank you very much. Now let's proceed to our third negative speaker. Lynn, you have 4 minutes to tell us why it is not practicable to decriminalize libel. Your time starts now.
Reputation is a fragile thing. This has never been more than today. Then just few keystrokes can initiate a massive and worldwide defamation on any person on a scale undreamed of in the past. Your honors, co-counsels, and to our spectators, good afternoon. We on the negative side opposes the move to decriminalize libel. Before I move to my arguments, I would like to counter the points made by the affirmative. The necessity speaker that it deters the freedom of the press. Let me iterate the Garrison case. A speech used as a tool for political ends does not automatically bring it under the mantle of the Constitution. For the use of the known lie as a tool is at once with odds with the premises of democratic government. The beneficiality pointed out that such liberties will be exercised more. Let me say that it is exactly why there must be a limiting power as well. It is expressed in Article 19 of our Civil Code that rights must be exercised with justice, observed honesty, and good faith. The practicability stated that civil case is enough preference for the civil remedy has substantially eroded that breach of justification for criminal libel laws. As today, there were those unscrupulous enough and skillful enough to use the deliberate or reckless falsehood as an effective political tool to topple an administration. That being said, I now present the points for the non-practicability of the proposition. First, it cannot be done as it exists to set boundaries. Second, libel doesn't only harm the individual, but the state as well. On my first point, let me reiterate that our first speaker mentioned, the law on libel was never meant to stifle the legitimate exercise of the right of expression and speech, but as a deterrent against its abuse. The Supreme Court already ruled in the case of Gingging versus the Court of Appeals and the people of the Philippines, whatever seeming conflict between these two percepts has long been judicially resolved with the doctrine that libelous speech does not fall within the ambit of the constitutional protection. The affirmative seems to have miserably failed to realize that decriminalizing libel likewise deprives those with legitimate grievances, as it is only the legal remedy available to truly penalize those who with utter malice besmirch names and reputations. Additionally, a serious evaluation of the current law on libel and jurisprudence suggests that there is no real need to decriminalize it, because there are more than enough defenses and legal doctrines that does not make it that easy to convict under normal circumstances, except in the most extreme and obvious cases. On which leads to my second argument. As a criminal case, one of the aggrieved parties is the state. The justification for criminalizing libel was to deter the publication of communications that were likely to cause a breach of peace, thus preventing injury to the safety, morals, and welfare of the public. Because it is also the collective right of the state and its people to have the right to social order. The court in Gingging case also mentioned that the law of defamatory libel was developed under the common law to help government protect itself and to provide an outlet for individuals to defend their honor and reputation so they would not resort to taking the law into their own hands. Ladies and gentlemen, to decriminalize libel is to render the state powerless. Despite the current status quo, cases under it continues and constantly increase at an alarming level. Just imagine the national specter that will arise if libel were to be decriminalized. Now is not the time to deter it. Rather, it is the time we must strengthen it. Libel itself is inherently wrong. It aggrieves not only the respondent, but the state. It is therefore appropriate and may become absolutely necessary to use some level of criminal liability to ensure that this information is free from maliciously introduced falsehood and distortions. With that, Your Honors, I rest my case.
Thank you very much, Lynn. You had 20 seconds left in your time. Now, Walbert, you have 2 minutes to cross Lynn. Your time starts now.
Do you agree with me, Counsel, that a free and fair media is the cornerstone of any democracy, right? Yes, Counsel. Thus, any encroachment as to media function should be strictly scrutinized, right? Right, Counsel?
I cannot hear you.
Counsel, yet for a democratic country like us, it is astonishing that we're punishing criminally our journalists for uncovering the truth. It is your responsibility, Counsel, to listen carefully. Counsel, do you agree that journalists are important in our democratic society, right?
Yes.
Thus, they provide information needed for intelligent public discourse, right?
Yes.
Thus, they should not be harassed through the filing of a criminal case that takes years to be resolved, right? And
Only
it is
the
appalling
people-
that if they provide
Only the
informal
people
reporting
who
to
lie
support
should be
being harassed
afraid.
through the filing of
Only
criminal
the
case
people who
against them.
know
Totally
that they are using
undemocratic.
lies.
Counsel, isn't it a law regulating free speech must be narrowly tailored as ruled by the Supreme Court in several cases, right? Chavez versus Gonzalez counsel, it should be
Again,
yes.
again,
Counsel,
libel.
do you
Libel
acknowledge
is
the
not
fact that majority
constitutionally
of Filipinos
protected.
are afraid
It
to
is
voice their dissent?
already in the
Counsel,
jurisprudence.
this is my time. Can you listen? Do you acknowledge the fact that majority of Filipinos are afraid to voice their dissent? Let me
Are you
read you a
sure?
data. Let me read you a data, counsel.
Because I can see it in
51% of
social
Filipino
media
feels
and in
that
the
it is
current
dangerous
status
to
quo
print or
that
broadcast
people
anything
express,
critical of the administration if it is truthful.
people express
Counsel, learn
their-
also to concede to some important talking points, counsel, especially
Oh.
when they are backed up with data. Thus, this data supports that our libel law is narrowly tailored, counsel,
So
right?
what is your question?
And totally, and because if it is not, because if it is narrowly tailored, we won't have an overwhelming majority who will say that they don't feel safe to voice out their dissent. Thus, the need to adopt the proposition because our libel laws continue to infringe the exercise of free speech, press, and expression. Counsel,
doubt
isn't it
that.
majority of the
I
first
doubt
world countries are decriminalizing libel already? Isn't it?
Not
Well,
all.
you failed to make your research about
Not
it. And we
all.
all know that big media's outlet are stationed in these first world countries, right? And therefore, we have no reason not to decriminalize libel because even in first world countries, they already decriminalize libel.
Because they are more
if there may be
disciplined.
minor
They are
repercussions
more
in adopting the
disciplined.
propositions, counsel,
And they have
those are
laws
part
that
of the
protect
solution of
everything,
upholding
the
democracy
state
and
and
the
the
right to
civil as
speech,
well.
press, and expression for everyone. Further, we have
Thank you
established a
very much,
mechanism for them.
speakers. Thank you very
Thank
much.
you.
Now, relax. Okay, thank you very much, speakers. That concludes our semifinals round for this afternoon. But before we proceed, may I ask our adjudicators to have the floor if they have something to tell or to comment about our speakers. Miss Alexis, do you have something to say? Hello.
I would just like to congratulate both teams. You certainly did not make judging this easy. You have great points, really great points, both of you. Congratulations. I hope that you guys can already relax. The entire debate is over. I hope both teams are okay and friendly with each other. Again, congratulations to all of you.
Thank you very much, Miss Alexis. How about Remy Viray?
Hello, can you guys hear me well?
Yes, po, we can hear you, po.
Yeah, I would like to agree with Alexis that this was actually the hardest part of my day. You guys did an awesome job. You guys, I can see brighter futures for you, and both teams did really well today. Thank you.
Thank you very much, Judge Hermie. How about Judge Dwight?
Hi. For some reason, I can't turn on my camera. I don't know. Zoom is messing up. Anyway, that was an average to above average round. I was actually surprised. Good job on both teams. That was really engaging and compelling debate. Good job.
Thank you very much, judges. Now, may I request the guests and our debaters to return back to the main session, except for the adjudicators, so that we can discuss who will be the best speaker, best debater, and the winning team for this round.
Thank you.
To our judges, hintayin lang po natin matransfer lahat sila sa main session before tayo magsimula. Thank you.
Hi, can I just reconnect for a bit to see if I can turn on my video? See, this is Dwight.
Okay po.
Okay, thank you.